Emma, sorry, if you, it's all right. Good afternoon. This is an open hearing of the independent inquiry into matters relating to Afghanistan. Please could I ask you to ensure that all mobile telephones and other personal electronic devices are either switched off or in silent mode. Please may I also draw your attention to the fact that the chair of the inquiry, the Right Honourable Sir Justice Haddon-Cave, has made a restriction order in relation to the conduct of those who are attending this and future hearings. The full order is displayed on the inquiry website and on the door of this court and of the media annex, but I will summarise its purpose. The order, which applies to this and to all future hearings of the inquiry, prohibits any person from making an audio or video recording of inquiry proceedings from within the hearing rooms without the express permission of the chair. Furthermore, no person may take a photograph in any room in which inquiry proceedings are taking place and at a time the inquiry is sitting without the express permission of the chair. For the avoidance of doubt, both of these prohibitions extend to the hearing in the media annex. A further part of the order arises as the live stream of these inquiry proceedings via YouTube will purposely be subject to a 10-minute delay. It is prohibited that any person may disclose, publish or broadcast in any form or by any means anything that is said or done in the inquiry hearing room until 10 minutes after it has taken place. If an application is made for a restriction order in relation to anything that has been said or done in the inquiry hearing room in the preceding 10 minutes, anything that was said or done during that period is subject to a restriction order prohibiting its disclosure, repetition or duplication until the chair has finally determined the application. All of the above orders are subject to a penal notice. This means that any breach of any element of the restriction orders may be certified to the High Court or the Court of Session, who will have the power to fine or imprison anyone found to have been in breach of the order. Court rise.
Mr. Glasgow.
Please, you, sir. Colonel Rotchell, I was about to take you to deal in similar terms with the 62 section SIB deployment. And to help you, can I take you immediately in your statement to paragraph 142 onwards? And it may be best if we were to start together at paragraph 144, because the mission of SIB UK is set out there by you, which is to provide fully trained, equipped and motivated personnel to deploy on operations, to provide an appropriate, serious and complex investigative capability, there to deliver independent, credible and timely investigations, regardless of environment within the OPHERIC theatre, in order to support the service criminal justice system and contribute to the moral component of fighting power. And then in terms of the obligations that sat upon the officer commanding 62 section, you've provided those to us as well, since they are part of the operational order taken from OPHERIC 16, which was relevant to April 2012 onwards. And amongst the tasks which fell to the officer commanding 62 section, react promptly to all incidents in theatre, provide a weekly crime brief, liaise with the National Directorate of Security, maintain effective collaboration with Task Force Helmand, JF and IE2 assets, investigate all SIRs on request from Command TFH or Command JFSPA, investigate all allegations of abuse of local nationals, adhere to the SF protocol when dealing with any SF personnel in theatre. Some of those will be obvious. Could I just ask you about two, and they are about numbers 5 and 7, please? Number 5 indicates that the officer commanding 62 section SIB is to investigate all SIRs, shooting incident reviews or serious incident reviews, depending on which definition you choose to rely upon, but to investigate all SIRs on request from Command TFH or Command JFSPA. Can you help us, please, with what that meant for the officer commanding 62 section SIB?
Yes, I'll try to, because I think there needs to be some clarity given to that, because on the face of it, it looks like it was the responsibility of 62 section to investigate SIRs. It wasn't. It was the responsibility of 62 section SIB to investigate any allegations that fell out of the SIR process. So that would have meant in the relevant time period that should an SIR occur and the SIR come to the outcome that a service police investigation may be required, and it was then referred over, that's when they would have investigated. And the other aspect of it is that it quite clearly states from Commander Task Force Helmand and from Commander Joint Force Support Afghanistan, so the two conventional commanders in theatre.
So just making sure that I've understood and that we've understood what you've just said to us in explaining the 5th of the 7 obligations that rested upon the officer commanding 62 section SIB. In terms of investigating all SIRs, that would be to investigate any shooting incident review which was forwarded to the RMP and in particular to SIB, because that review had concluded that there may be evidence to support a serious criminal offence having been committed.
Yes, that's correct.
Okay. And that would be an SIR which had been forwarded from either Command TFH or Command JFSPA, or because they've been asked by one of those two command heads to come in and deal with the matter?
It would ordinarily come from one of those two because of the policy which saw a commanding officer complete the first part of the shooting incident review, and then it go to the one-star commander for their ratification and decision. So they would ordinarily have sat with the one-star level command, so with Task Force Helmand or Joint Force Support Alpha.
And of course, just reminding you of the evidence you've given to us before in terms of steps taken to launch an SIR, the regulations require that the commanding officer is to liaise with the service police and with legal advisors as soon as practicable before initiating a serious incident or a shooting incident review.
Yes.
And coming back to where we had been when we considered the nature of the allegations that fall within the ambit of this inquiry, if the allegations are correct and that we are considering allegations of extrajudicial killing or of murder, those are not the sort of allegations that would have necessitated a shooting incident review. The commanding officer should have referred them immediately to the Royal Military Police.
Yes, immediately.
As far as the 7th of the 7 items is listed in the operational order there, the officer commanding 62 section SIB is to adhere to the SF, the Special Forces Protocol, when dealing with any Special Forces personnel in theatre. So there is a particular protocol which applied to investigations involving members of Special Forces.
That's correct.
And we'll be able to look at that with your help in a little bit more detail a bit further on. I'm not going to leave it there, but I just want to move on in your statement to deal with other matters, and we'll come to it in the order in which you've set it out, because that's likely to be easier for you. You'd already told us, insofar as it is necessary to repeat it, that the operational command in Afghanistan was retained throughout by Provost Marshal Army.
Yes.
And that the reason behind that is to ensure that there is the independence in any investigation, so that everyone knows that there is no difficulty when an investigation begins, that it's the Provost Marshal Army who will be running things and the RMP who are in charge, rather than a different chain of command?
Yes.
What I'd like to do with your help, please, is to turn to consider the role of the Force Provost Marshal, because you touched upon that at the very outset of your evidence when we dealt with the summary. What I'd like to do with your help, please, and I'm turning to consider in particular paragraphs 165 and 166, the role that the Force Provost Marshal was to play, how he or she sat within the chain of command, and what particular advisory role, if there was one, that he or she might play in the investigation of serious allegations or incidents. So could you please help us, please, with the structure of the chain of command and where it was that the Force Provost Marshal or the FPM sat?
Yes, certainly. So the Force Provost Marshal was an OF4, so a Lieutenant Colonel, Royal Military Police Officer, who sat within the Joint Force Support Afghanistan headquarters. So the one-star headquarters, which I think yesterday was referred to as the National Component Command headquarters. Unlike the formed RMP units that remained under the operational command of Provost Marshal Army, certainly for many, if not all of the rotations, the Force Provost Marshal was placed under the operational command of the Chief of Joint Operations. They were in essence deployed as an individual augmentee rather than as part of a formed unit. And within that, they then sat under the operational control of the commander of Joint Force Support Afghanistan. The Force Provost Marshal themselves had tactical command of both the Theatre Provost Company and 62 Section SIB, which, if I can very briefly summarise, meant that he or she could give them tasks to do, but only if those tasks sat within the mission set that they had been given by Provost Marshal Army, which again is both a freedom and a constraint. It's a freedom to allow him or her to use their flexibility to address issues, but there's a deliberate constraint to prevent them from removing the RMP assets from anything other than their specified roles in supporting what has been set by the operational commander in PM Army. In terms of the Force Provost Marshal's then responsibilities towards investigations, I think that's important that they had responsibilities in terms set out by Provost Marshal Army in the direction that he gave to the Force Provost Marshal in relation to volume crime. And by volume crime, it's those lower level or less severe and less complex offences investigated by the GPD elements, but not in terms of serious and complex crime in terms of the investigations undertaken by the SIB. I suppose if I were to try and simplify that, I would say that the Force Provost Marshal was in a position where he could direct that an investigation should be considered, but could not impact or interfere with the manner in which that investigation was undertaken, particularly by the SIB elements undertaking it.
In terms of the sort of advice that the Force Provost Marshal might provide, did that include professional policing advice?
It would almost certainly have included professional policing advice to the commander that they supported.
And in terms of that sort of professional policing advice, might that include advice as to whether the RMP needed to be informed of an allegation or an incident?
Yes.
And would it include whether or not a commanding officer should initiate a serious or shooting incident review?
It would seem so, given that there was a role for the RMP, particularly the Force Provost Marshal, in those processes, and given they would go through the headquarters, they would almost be the most or the best placed person to do that.
So one shouldn't be left thinking that the commanding officer was left on his or her own to reach conclusions about how best to comply with the legal obligation that fell upon them.
No, and certainly in addition to the Force Provost Marshal, in this specific instance and in the UK, when not on operations, each formation has legal advisors who represent the interests of that formation.
So the commanding officer had the option, if he or she chose it, to take legal advice about the position in which they found themselves as regards an allegation or an incident that had been brought to their attention. And they could also take expert policing advice about the most appropriate response that there might be in policing terms, namely either a report to the RMP or the initiation of an SIR.
Yes, that's correct.
If such advice was given by the Force Provost Marshal to a commanding officer, would a record have been made of that advice?
Yes, sir, it should have been, and there are multiple iterations of the policy, and I can't recall all of them off the top of my head today, but certainly versions I have seen in the past have a space on the SIR form for those comments to be inputted were they provided. Much in the same way any advice from other experts would be so.
Other than including within the body of the SIR itself any advice that had been received by the commanding officer, would the Force Provost Marshal individually have to record his or her own device in a separate RMP document, or for example in a workbook or the like?
I would certainly expect them to do so.
The significance, of course, being that where you provide expert policing advice to a commanding officer that is relevant to the exercise of his or her duties, it would be expected that you would record that advice so that you could recall it as and when you needed to, and that others could understand the rationale that might lie behind your advice.
I can see no reason why someone wouldn't do that.
I mean, in very simple policing terms, it's incumbent on investigators to record the rationale between the decisions they take and the advice they might give.
I agree.
Can I ask you a little bit, please, about the Brigade Provost Officer, which we touched upon very briefly before. BPO is the abbreviation, and you were right to observe at the time that we might come back to deal with that individual. Insofar as the particular role of that individual is concerned, there were many different roles that he or she had to fulfil. But what of all the roles was the most important, please?
The most important and perhaps the most critical was advising the chain of command on what we would refer to as CPERS or captured persons issues. And at various times throughout the relevant period, it was also the role of the Brigade Provost Officer to monitor detention operations within Task Force Helmand. And that could be providing advice on both the practicalities of conducting detention operations for conventional forces, such as we heard yesterday from Brigadier Ebel about reinforcing the importance of not utilising prohibited techniques. It could involve pre-planning and providing advice and support on the logistical challenges faced when taking or when capturing personnel. But also reminding staff officers at the planning level in a headquarters, along in conjunction with legal colleagues, of ensuring that detention is carried out correctly and the lawful basis for detention was applied, and certainly where it wasn't, to ensure that it was rectified very quickly.
So in terms of the Army's detainee handling approach, the brigade provost officer sat at the pinnacle of that in terms of ensuring that it was properly and legally conducted.
Yes, in the main. I mean, the brigade provost officer is a detached officer from the theatre Provost company, sat inside, or was sat inside, the task force Helmand headquarters. So they themselves were not decision makers, but were a key advisor to the commander and to the staff.
In terms of what might ultimately happen to any detained individual, as of 2011, was the Afghan Prosecution and Support Section established?
To the best of my knowledge, yes.
And was that designed to provide support and mentoring to relevant Afghan officials in order that where prosecutions might take place, those responsible for taking them forwards were able to do so?
Yes.
Now, I appreciate that you are not a lawyer, and many would say the same thing of me. But insofar as it's relevant to identify potential differences in a very broad sense between Afghan and UK law, because it may be relevant as we move forwards, are you aware of certain key differences that had an impact as to whether or not individuals who had been detained could be prosecuted?
I am, and I can give you a layman's perspective on it, I hope, which is, you know, ultimately the Afghan authorities at the time required different types of evidence to that which we would be used to seeing in a court in the United Kingdom. What they required for consideration of a prosecution at the time was physical evidence from the scene of capture, including weapons, phones and notebooks, or any other incriminating evidence, witness statement from members of the detaining unit, ideally an Afghan national soldier or police officer, so they could appear.
Just interrupting there.
Sorry.
Presumably because by taking a statement from a member of the Afghan National Security Force, they would be able to assist any prosecution by giving evidence, whereas a UK service person might struggle to be understood.
Absolutely, and equally, it's not always appropriate or possible for UK service personnel to give evidence in that setting, potentially further down the line. So the ideal was to ensure that the Afghan forces were able to provide that evidence to satisfy the court. Because the judges at the time, and certainly from my own recollection and from the documents that I've reviewed, absolutely required the individual to come before them and give evidence rather than just accepting a statement. And then the other key aspect was where there was photographic evidence as opposed to physical evidence, to ensure that that photographic evidence showed both the detainee and the incriminating evidence. So a picture of an AK-47 on its own was unlikely to be sufficient, but if it was with the detainee, it was likely to meet the acceptable standards for the Afghan court.
And I think that one of the other required pieces of evidence was a statement from the detainee as well.
Yes, sorry, it was.
It's my fault I interrupted you when you were going through the list. Given the difficulties of dealing with detention operations and searches and arrests that might become kinetic, and in an environment like Afghanistan, was it always easy to be able to produce the evidence that the Afghan courts wanted to have access to in order for a prosecution to be taken forwards?
No, absolutely not. It was often a significant challenge.
and was one of the reasons that the Afghan prosecution and support section was created, was in the hope of minimising the numbers of detainees who had been captured and handed over, but who were then subsequently released by the Afghan authorities because there was insufficient evidence to prosecute.
Yes.
We've spoken thus far about the deployment of the RMP either in their GPD role or in their SIB role, but that has been with conventional forces. Can I invite you, please, in your statements to paragraph 175, and have you considered from the available material whether UK Special Forces operations had a similar close support policing role that's akin to the conventional forces which we've been discussing over the last couple of hours?
I have been able to consider that, and from my personal knowledge and from that information, I can't see that there was a similar role to those with conventional forces.
From your knowledge and from your assessment of the relevant documentation, were any members of the RMP attached to UK Special Forces in order to provide assistance to them in the work that they undertook?
Yes, and what I can see from a review of the available documentation is that at least 2 female GPD junior NCOs were employed in female searcher roles with UK Special Forces during the relevant period.
Is that in recognition of what we dealt with Admiral Radakin, that in order to recognise the cultural sensitivities and proprieties, it was deemed necessary for a woman to search a woman if a woman was detained in a compound?
That's my understanding, yes.
So from your review of the available material, you understand at least 2 female GPD junior NCOs were employed as female searchers with UKSF during the relevant period?
Yes.
Might there have been more, or is it only 2 that you've been able to identify from your analysis?
I've been able to identify 2 from detailed records. We have searched further and we've been unable to identify further instances, but it is absolutely possible that there were other instances of this being undertaken.
Insofar as there is still any policy of permitting RMP personnel to be considered for roles within UKSF, is there any policy or procedure that's now in place to determine who, if anyone, should be assigned outside of the routine RMP roles?
So I think there's two aspects to this, so if I may. The first being, if an individual from the RMP wished to serve in their own right in such a role, there would be nothing that precluded them from doing that. Hence, if they wanted to become a member of UK Special Forces. But secondly, and I think more importantly, there are now procedures and practices in place, which have been put in place by the current Provost Marshal Army, Brigadier Pringle-Smith, to make sure that any role that an RMP officer or soldier undertakes or is planned to undertake that could involve deployment with UK Special Forces is considered, and the impacts of it on both the individual and the organisation are understood. And I'm aware personally of, in the last 6 months, 2 such instances being prevented for that reason.
So is this a relatively new change that has been brought in by Brigadier Pringle-Smith?
Yes, it is.
And she's done so because she's recognised the need to take care before such attachments are agreed upon?
Yes, that's correct.
And she's looking, in that regard at both the impact on the wider RMP as well as the potential impact on the individual who might be seconded.
Yes, and also on the wider defence capability.
We have dealt very briefly with the potential context and challenges of investigations in Afghanistan, and it's been touched upon by other witnesses. And I'm not going to invite you into a detailed exposition of the problems that were faced by your personnel and your officers, but is it right to observe that conducting investigations in operational environments provide a unique set of challenges to those who are in charge of them and who are running the investigations?
Yes, that's correct.
Not least because you are conducting an investigation in the middle of an armed conflict.
Yes.
So there is the potential for a situation to develop and to descend into kinetic or violent activity at a moment's notice.
Yes.
And one has to be cognizant of the potential risks to SIB and RMP personnel when they are asked to embark on any form of investigation. Obviously, unlike the Home Office police force, the RMP are specifically trained and better equipped to deal with the sorts of difficulties that an armed conflict will bring about. But were there any particular problems that you and your service had not anticipated that might be faced by the RMP whilst in Afghanistan?
There are certainly challenges faced in Afghanistan. Many of them are known challenges because they've occurred in previous conflicts. Some of them are very difficult to manage within the RMP's resource. We've mentioned the threat to life of both those investigating, but also the broader threat to life of those people who are trying to provide security to those that are investigating, who are not only in danger but are taken away from their routine roles to do that. But I think one of the big challenges is getting to the location that an incident is alleged to have happened as quickly as possible, ideally within that golden hour, and then being able to preserve a scene for long enough to be able to undertake the level of forensic examination that one would ideally wish to see.
If we think about it at its most simple level, unlike conventional police forces who can readily summon up a van and constables to attend a crime scene, to cordon off the streets or the area with tape and to ensure members of the public don't wander through it, travelling from wherever your personnel were based to a crime scene might often involve travelling hundreds of miles.
Yes, utilising the same helicopter that might be required to evacuate a wounded soldier the other way, and hence the principles of investigations being preservation of life being number one. Also, other ongoing military operations might have moved resources into different places. And then I think it's also really important for us to be aware of the cultural sensitivities that at times affected the ability of the RMP to investigate in the same way that it perhaps would have done in Germany or in Cyprus.
In terms of the RMP's ability to conduct what are commonly referred to as house-to-house inquiries, was the same sort of exercise really ever possible within the confines of the compound complexes that you were working?
I think it would be fair to say rarely, if ever, given the threat to our own personnel to do so.
And in terms of access to injured or deceased individuals, was that something that was found to be difficult?
Yes, and those cultural sensitivities of, if I deal first with The deceased, cultural standards and norms within Afghanistan often saw people buried very quickly, often not in well-marked areas. So there's a challenge there. There's also the second order challenge of what impact on the wider security of the region and on the population in a counterinsurgency campaign would the enforced removal and potentially conduct of autopsies have on those dynamics, which I think are really relevant to be aware of.
And leaving aside the cultural, geographic or environmental impediments that there might be to your personnel and officers conducting an investigation, might there be other operational reasons that could lead to a delay in effecting a prompt investigation once matters became known?
Absolutely. In land operations such as those in Afghanistan, we often refer to a term known as the battle space. And in the same way every soldier has a commanding officer, every battle space has an owner. And the officer or the chain of command that owns that battle space is ultimately responsible for what goes into it, goes on in it, and what comes out of it. So for the RMP, in the same way as any other military personnel, on occasion would have to get the authority of a battle space owner to be able to identify, to allow them to go into it. And that, on the face of it, may sound preclusive, but it's another reality of operations, partly so that battle space owners know who and what is in their area. They have to be aware of what's going on so that they can minimise any fratricide or impact, but also so that they can manage the resource that's available across their wider area of operations.
Just leaving aside the battle space owner for a moment and considering the commanding officer, so the CO, did a CO have any power vested in him or her to delay a service police investigation? If it helps, I'm looking at your paragraph 192.
Thank you. Yes, there were times and circumstances where it was clearly set out in policy, and I'm particularly referring to one of the versions of the SIR policy here, and it's certainly in both the 2010 and 2012 versions. But at paragraph 19, it does say that where the service police have commenced an investigation, a clear duty exists upon every service person to assist the investigation. However, the CO retains control of his area of operations, and he may refuse the service police request to visit particular locations or carry out investigatory activities if the security situation demands. It then goes on to list a number of factors that might include, but is not a list that's limited to those.
In terms of any delay that might be occasioned by the refusal to grant the service police request to visit a particular location or carry out other investigatory activities, is there any limit to the delay that could be imposed?
There isn't any limit, but it's for the minimum amount of time required, and it's reflective of the operational reality. Some situations pass very quickly and others take more time.
Presumably there's an expectation that a policy such as that would be applied for proper operational reasons rather than simply an arbitrary or unjustifiable reason.
It would have to be justified and not arbitrary, yes.
Would any decision taken by a commanding officer to refuse a service police request be recorded in writing?
I don't recall, without checking the policy, whether there was a requirement to do so. However, it would seem to me good practice from both the service police perspective and from a chain of command perspective to ensure again that the rationale that sat behind and supported that decision was clearly documented.
Were any reviews undertaken of any decisions by commanding officers to refuse service police requests?
So, in the broadest sense, I conducted another search of our system in order to try and answer this. And from searching from early January, or the 1st of January 2010, through to the end of 2020, I could see no service police investigations in Afghanistan into Armed Forces Act offences that would be likely to lead to this, with one exception, which I believe we will cover later on in the statement.
So you've not been able to identify any service police investigations into offences, for example, of obstructing a service police investigation?
No, less the one that we will cover.
Or at least what that means is there were no reported obstructions that were brought to the attention of the service police?
Yes.
Insofar as there may be any difference at all between investigations into the conventional forces and investigations into special forces, were or are there any differences?
I mean, fundamentally, investigations into UK Special Forces and its personnel are conducted in the same way as any other service police investigation, in line with best practice, with our own doctrine and our own policy. And as I've already highlighted, but the Manual of Service Law makes no differentiation, nor does it apply any exemptions to any units or formations within the UK Armed Forces, including UK Special Forces. The statutory requirements don't change, and ultimately the law applies equally to all military personnel all the time. So fundamentally there was no change. However, there were protocols that existed between the RMP and UK Special Forces with the aim of ensuring that highly sensitive operational activity was protected.
And just to be clear, those protocols that existed did not have any impact on the statutory obligation on a commanding officer in Special Forces to report an offence that may have happened to the RMP?
Absolutely not.
Insofar as those protocols existed and continue to exist, can I just ask you briefly about them, please? As part of the 2008 protocol, did it highlight that it is incumbent upon all Special Forces personnel to assist the service police when they are undertaking one of their investigations?
It did.
So akin to the advice that had been given under the Queen's regulations, but this is specific to SF personnel, that it is incumbent upon them to assist the service police when they're carrying out an investigation.
It does, yes.
Insofar as there might be any delay possibly caused to a prompt investigation, was there any option for a delay to be brought about to the start of an SIB investigation into matters concerning UK Special Forces?
Not to the start of an investigation, but it did highlight a principle in which UKSF personnel involved in an incident that required investigation were permitted a period of 24 hours before statements were taken from them by the SIB. So the investigation would have commenced, but some aspects of pursuing lines of inquiry would have delayed.
But if we consider that for a moment, an allegation of serious wrongdoing alleged against UK Special Forces is brought to the attention of the RMP and an investigation therefore begins. But the RMP might not be able to speak to the service personnel involved in that allegation for a period of up to 24 hours.
That's written in the protocol in both the 2008 and the 2013 version. It's not in place in the 2016 version. But I think it's really important to highlight here that whilst that is written in those protocols, there is the ability of the RMP to not follow the principles in that protocol if they think to do so would actually challenge or hamper the investigation.
So the protocol, as far as the RMP is concerned, is advisory rather than any form of legally binding document?
It's absolutely the view of the RMP that it's not legally binding.
Might there not be a risk that there then becomes a standoff between the RMP, who say, we want to speak to you come what may, and the Special Forces who say, we'll see you tomorrow?
I think that's very fair. Yes, it's likely.
And in that particular tug of war, who's going to win?
The law should prevail.
How often did you find it did in those situations?
I mean, I can't personally answer that question.
Can I ask, what was the rationale for the 24-hour moratorium period?
Well, so I can see from other documents that I've had access to from around the time that was likely to mirror some of the provisions that were put in place for police officers involved in certain incidents within the UK, notably armed police officers who discharge their weapons within the line of duty.
Did the policy offer any guidance or advice to members of UKSF about what they should or should not do in that 24-hour period?
Do you mind if I just consult with the
Please.
exhibit?
Or Exhibit KR61.
Thank you. So, sorry, KR61 is the 2016 policy there, which has that removed. However, I believe from recollection that the 2008 policy, which was the one in place for the majority of the relevant period, talks about the ability of those UKSF personnel to be supported by an Army Legal Service legal advisor.
So in the 24-hour period between the SIB being made aware of a potentially serious criminal offence committed by UKSF, the SIB could not speak to the UKSF, but the UKSF could speak to a lawyer.
It appears so, sir.
And presumably to each other.
Presumably.
insofar as the RMP did not regard these policies as legally binding, are you personally aware of any occasions when your SIB officers or your RMP soldiers sought to disapply the protocol and insisted on speaking to UK service personnel inside the 24-hour window, or is that not something you're able to answer?
That's not something I'm able to provide any clarity on, sorry.
Can I just take you to your paragraph 201, please? And in keeping with what you have said about the policies and the protocols not being considered to be legally binding by the RMP, do we find an entry in the Military Police Investigative Doctrine which states that fundamentally there must be no deviation from the general policy when RMP investigate incidents involving SF or other specialist units? All personnel are subject to service law and must be treated with parity.
Yes, that's correct.
Insofar as it might be possible to link offences by the individuals who have reported them, is that something that you are able to do to see if there is a pattern in offending that lies within the relevant period?
To a certain extent, yes, but there are practical difficulties with our current IS system on being able to do that, in that it doesn't fully, it doesn't allow us to search easily the unit from which a complainant has come from. But what it does allow us to do is search for a complaint against an individual from a unit. So part of the puzzle, but I would accept not every aspect of it.
So if more than one person from the same unit were the subject of a complaint, that could be identified. But if the same person from a unit had made more than one complaint about different units, that could not be identified easily.
Not easily. And I think there's another factor to this as well, which is around the use of intelligence for analysis when you utilise ciphers, for instance. And that's not to say they shouldn't be used, but where you apply ciphers specifically to an investigation rather than a unique identifier that stays with an individual, it becomes even harder to use that mosaic process to generate trend analysis.
That may be one of the problems that we will have to grapple with during the course of this inquiry.
Yes.
There are occasions where individuals are given more than one unique identifying number.
Yes.
But is there now a proposal that has been made to UK Special Forces by the RMP and the Defence Serious Crime Command that a lifelong cipher should be applied to UK Special Forces personnel so that that number will remain with them throughout their service?
That's certainly the intention of the Defence Serious Crime Command and mirrors the way that other protected communities across the UK are managed and dealt with.
Can I turn to part 3 of your statement, please? And I'm going to invite you to look at paragraphs 204 onwards, which deal with Operation Northmoor. And what I'm going to endeavour to do, though it is bound not to work, so I will apologise now, is to try to take it in a chronological order. Yes. I don't mean that as a discourtesy to you, because what you have done is to answer the specific questions that were asked of you, and you've done them in the order in which they were asked. So the fault is mine. I asked the questions in the wrong order, but I will try to help you to put your evidence into a chronological order, since that is fairer on you and easier on anyone trying to grapple with this. If we start initially with this observation, insofar as your involvement, if there was any, in Operation Northmoor, can you tell us, please, whether you were involved in the planning, resourcing or execution of Operation Northmoor?
No, I was not involved in either the planning, the resourcing or the execution of Operation Northmoor.
And so insofar as you are able to assist this afternoon with any questions I might pose about Operation Northmoor, are your answers dependent on the material to which you have had access, which has afforded you some knowledge of the operation and its history?
Yes, that's correct.
I'm not going to descend into the minutiae of the granular detail with you. I'm going to try to keep it at a relatively oversight level if I can. If I ask a question that you're not able to answer, just simply tell me that that's the position, okay?
Thank you.
Can we look together, first of all, to your paragraph 205? And was Operation Northmoor the overarching name for multiple investigations which initially began into detainee abuse and then turned to consider allegations of unlawful killing?
That's correct, yes, it was.
And were there two separate lines of investigation, one that was being conducted by the RMP under the title Project Elsinore, and another by the Royal Air Force Police under the title Operation Isotopic?
Yes, that's correct.
And both those investigations being made at that time into allegations by detainees that they had been subjected to sexual assault and mistreatment whilst they were detained by UK Armed Forces.
Yes.
And was the result that, in effect, the RMP and the RAFP were effectively investigating multiple allegations of very similar sorts?
It was, and in that time period, Provost Marshal Army noted the potential overlap in these two key investigative activities, Operation Isotopic and Project Elsinore, and he was concerned that it could lead to investigative opportunities being lost. He was concerned that any wider systemic and organisational matters may not be picked up appropriately, and he raised this into the MOD, and his view at the time was that it made sense for them to be grouped together under one overarching investigative strategy. I think he was also concerned that as combat operations in Afghanistan were drawing to a close, that if this didn't happen quickly, further investigative opportunities could be lost.
And the PMA at the time was Brigadier Bill Warren?
It was, yes.
And did he take the decision in March of 2014 that those two separate streams of investigations would be grouped together under the title Operation Northmoor?
Yes, he did.
In view of the scale of the now merged investigation, was it decided that the RMP was the only police force with the resources to conduct such an investigation?
It was, yes.
Was consideration given to the fact now that the Army were investigating the Army?
Yes, consideration was given to it, and I can see from decisions that were made at the time that both Provost Marshal Army and Provost Marshal RAF did consider a 2011 Court of Appeal ruling regarding the Iraq historic allegations team. But at the time, Provost Marshal Army felt that the risk of doing nothing was greater than the risk of the RMP investigating.
Once the investigation had been taken over by the RMP, and they began to look at everything in the round, in October of 2014, the RMP made aware of an allegation of unlawful killing during the course of an operation in which relatives of Mr. Bang had been killed.
Yes, that's correct.
He, Mr. Bang, had previously made an allegation of unlawful treatment whilst he had been detained. But you are now informed that during the course of the same operation, relatives of his and other individuals had lost their lives.
Yes, that's correct.
At the time that you were provided with that information, were the RMP given any direct evidence from either the complainant, Mr. Bang, or Mr. Cy Fuller, in support of the allegations?
Not at the time, no.
In order to try to work out what operation, if any, might be relevant for your investigation, did Operation Northmoor and its investigators in effect cross-refer the dates with operational records to see if an appropriate operation could be identified?
They did, and they identified an operation.
And was that from the 16th of February of 2011, known now as Objective Tyburn?
That's correct, it was.
An operation which resulted in 4 dead Afghan males and the recovery of 2 AK-47s?
Yes.
Can I take you on in your statement, please, to paragraph 221? At the commencement of Operation Northmoor in March of 2014, was it first based in Bulford and had at that stage a staff complement of 9?
It did, yes.
By December of 2014, now seized of the 2 different investigation streams as well as the allegation made by Mr. Bang and Mr. Cy Fuller, was it now determined that additional personnel would be required?
Yes, it was, and the figure that was considered to be appropriate was 123 personnel in total.
In terms of where was best to house the operation, was consideration given to moving from Bulford to more specialised premises?
Yes. Ultimately, Bulford was not resourced in a way to be able to support the number of personnel required, and didn't have the right infrastructure to manage some of the complexities and sensitivities of some of the information that was required to be examined as part of Operation Northmoor. So consideration was given to other sites where this could be best achieved.
Which site was chosen to house the investigation, please?
So ultimately the site that was chosen was RAF St Morgan, which is in Cornwall.
Was it expected that everything would be established there by the summer of 2015?
It was, however, due to some resource issues at RAF St Morgan, most of the personnel that were due to move in 2015 and commence work there didn't move there until early 2016, with the majority of personnel being in place by September of 2016.
And by September of 2016, had the number of personnel on site at RAF St Morgan reached 110?
Yes, it had.
Were the staff for Operation Northmoor divided into 3 different teams?
They were. Would it be helpful for me to give a quick breakdown of what those teams were?
Yes, please, Colonel. Thank you.
So, Team 1 dealt with Schedule 2 offences, so the most serious offences, including the unlawful killing allegations. Team 2 conducted the other detainee abuse allegations, those that were both criminal in their nature and non-criminal conduct offences. And then Team 3 consisted of the supporting elements, including the disclosure teams.
if we just think in terms of numbers for a moment, September 2016 saw some 110 personnel comprising Operation Northmoor. What, if any, steps were taken to try to avoid RMP personnel being deployed to RAF St Morgan when they had previously been deployed in Afghanistan?
So, from my own recollection at the time, anyone who was being assigned to Operation Northmoor had to declare all of their previous service in Afghanistan, and individuals that met certain criteria were precluded from being involved in Operation Northmoor.
Was it a struggle to find people who were not conflicted out and who could work for Operation Northmoor?
I don't know if it was an intense struggle, because we did manage to find enough people, but it certainly limited the pool that was available to do that work from an already small pool. So it impacted more widely on the ability of the SIB to choose who it wanted to do things.
And leaving aside the question of whether or not it's possible, given the chain of command, to direct somebody's attendance at a particular location to carry out a particular stream of work, in terms of finding people who wanted to go to RAF St Morgan and to work there, was that a challenge?
Yes, it was.
Is that because it's a relatively remote location, certainly some distance away from other RMP locations?
It is, although on the absolute flip side of that, some people were very keen to go and live in Cornwall, but it's not a location that traditionally the RMP has operated in, and those people with roots elsewhere, it was a long way away.
Can I take you, please, to paragraph 227 for a moment? And we're still dealing with early on in Operation Northmoor. At the outset of Operation Northmoor, was advice being taken by outside policing agencies?
From late June 2014 onwards, yes, advice was taken.
And insofar as any particular advice of relevance was provided by an external policing agency, was there advice about how the structure of Operation Northmoor might need to be reset?
There was. Initially, when Northmoor was declared by Provost Marshal Army, he appointed himself as the Gold Commander. The advice from the external policing agency and their PIP4 advisor was that by retaining that role himself, he potentially compromised his independence, not in general, but specifically relating to any authorities required under the Regulation of Investigatory Powers Act, which sets out that for certain things to occur, they can only be authorised by the chief officer, and therefore he needed to be able to delineate his two potential functions there. So on the back of that advice, Provost Marshal Army and Brigadier Warren at the time revisited his initial command structure, and I can see from a log of events in July 2014, he then appointed a different officer, an officer of Lieutenant Colonel rank, as the Gold Commander for Operation Northmoor.
And insofar as we need to, the Gold Commander, who sat above the Silver Commander, who sat above the Senior Investigating Officer, was this a command structure that had been absorbed from the Home Office police forces?
It was, yes.
And was the role of the Gold Commander to provide an effective and accountable investigative response to the allegations?
It was, yes.
And was it the role of the Silver Commander to supervise and manage the investigation teams and to direct operations staff to investigate in line with the terms of reference?
It was, yes.
And as far as just concentrating on Team 1, which is the allegations with which this inquiry is concerned, was the SIO from Team 1 expected to investigate allegations of unlawful killing within the parameters of the terms of reference and in accordance with any strategic direction given either by Provost Marshal Army or the Gold Commander?
Yes, they were.
Can we come back, please, to your paragraph 212? In fact, no, I'm sorry. Can we start with 211? I do apologise. We've just dealt with advice given in early summer of 2014. Can I take you now to January of the following year, 2015? And at that stage, did a serving member of the military approach the RMP with information that suggested that unlawful killings may have occurred?
Yes, they did.
Did that individual raise concerns in particular about the period in 2011?
They did.
And indeed the period that the RMP were already looking at as a result of Objective Tyburn and the complaint made by Mr. Bang and Mr. Saifullah?
Yes, that's correct.
But whilst the RMP were already aware of the allegation being made in respect of the incident complained of by Mr. Bang and Mr. Saifullah, was this now the first time that the RMP were aware by any member of the UK armed forces that might offer support for the allegations that unlawful extrajudicial killings had taken place?
It was, yes.
But was this more than one instance of such an allegation? Did this raise the possibility of systemic issues because it was unlawful killings, not just a killing?
That's correct.
Insofar as now, with the possible identification of systemic issues having arisen, were any steps taken to try to separate what political interest there might be in Operation Northmoor from the more granular tactical level of the investigation itself?
Yes. So in 2016, Provost Marshal Army changed over, and the subsequently Provost Marshal Army at the time gave direction that the MOD, or he felt the MOD, would benefit from being given greater awareness of the higher levels of Operation Northmoor, and particularly the more serious aspects of the alleged offending and allegations. So that resulted in more routine meetings between Provost Marshal Army and members of the Ministry of Defence, with the Permanent Undersecretary acting as a firewall between the investigation at the strategic level and then the political level of leadership within the Ministry of Defence.
In terms of whether or not that was an effective firewall, are you able to help with that or not?
I don't think I can, sorry.
And insofar as that was the decision of the new Provost Marshal Army, was that Brigadier Dave Neal?
It was, yes.
Can I take you, please, to paragraph 237? And we'll try to continue in the chronological order because the firewall was in 2016, and what I'd like to take you to, please, is the summer of that year. And following the appointment of Brigadier Dave Neal, did he, as Provost Marshal Army, put in place additional insurance that was designed to provide external advice and review of the investigation?
He did, and he put this assurance in place due to the complex nature of the investigation, and he sought the support of a prominent King's Counsel or Queen's Counsel at the time, and also a very experienced former Chief Constable, and engaged them in an independent advisory group in line with national best practice to do so.
Were they appointed in September of 2016 to act as the IAG, the Independent Advisory Group?
Yes, that's correct.
And was their initial advice that it was necessary and appropriate to conduct an external review of the investigation?
Yes, by an independent review team.
And was an independent review team set up comprising 2 retired senior detectives at the end of that same year, 2016?
It was, and they conducted their first review during January and February 2017.
Bless you. And having conducted their first review, did they make several recommendations that were at odds with the direction in which the investigation had hitherto been travelling?
They did, yes.
In particular, had 2 individuals been identified as suspects?
Yes.
And did they offer in their assessment of the investigation that it was premature to designate anyone as a suspect and that plans to arrest them ought to be put on hold?
They did.
So when you speak of them making recommendations that were at odds with the direction that had been given before, is that the change of direction?
Yes.
Before they arrived, there were 2 suspects in the line of fire, if that's not an inelegant phrase to use. But following their arrival, they were no longer suspects, and the investigation was refocusing to see whether evidence could be gathered.
It was. Ultimately, the independent review team didn't believe that there was sufficient evidence to justify the strategy that was currently in place.
At the same time that there was a readjustment of the strategy, was there also a reconsideration of the terms of reference that were relevant to Operation Northmoor?
There was a reconsideration, and it also coincided with a change of Gold Commander, and the updated terms of reference changed the focus. Or sorry, they didn't change the focus. They removed from the terms of reference the term systemic issues, because they, on the advice from the IAG, they determined that it was for the investigation to purely focus on criminal aspects or potential criminal aspects, and allow systemic issues to be dealt with elsewhere within the Ministry of Defence.
For anyone who's following in your statement, if they haven't found it already, it's paragraph 218, with the terms of reference revised on the 15th of November following the recommendation from the IAG. And did that see the removal of any reference to identifying systemic issues, in other words, wider issues or lessons that could be learned, since the view had been taken that those were not in themselves criminal?
It did, and it highlighted that these matters were to be referred to the Systemic Issues Working Group within the Ministry of Defence.
But what about systemic issues in the sense of patterns of behaviour? What was the view about those, if that was considered at all at this stage?
I'm not sure I can offer you any clarity on that, sir. I apologise.
Could I just ask this before perhaps it's time for a break? By removing the scope, right, by taking out of the scope of the investigation the consideration of systemic or patterns of problems, is there a risk that the focus then becomes very particular onto the individual allegations themselves, rather than allowing the investigator to have a broader perspective encompassing everything that might be said to have gone wrong in a given period?
I think there's potential that could happen.
So would that be a convenient moment for a short break this afternoon? As a courtesy to everyone, can I indicate that, subject to anything that anyone wants to bring to my attention, I'm confident that I will conclude Colonel Rotchell's evidence this afternoon, and certainly before we need to rise at about 4:30. So I hope that's good news for everyone.
Indeed. Thank you, Mr. Glasgow. Let's reconvene at 27 minutes past 3. Mr. Glasgow.
Please, you, sir. Colonel, still dealing with Operation Northmoor, can we just look, please, in your document to paragraph 225? And at the outset, when we dealt with your summary, you told us of the size of the investigation, the number of complainants, and the number of allegations which needed to be looked at. But by early 2017, was the number of allegations significantly reduced after consideration was given to a decision by Mr. Justice Legat in the IHAP proceedings about whether or not investigations that were unsupported by a statement from a claimant needed to be pursued?
That's correct, and the number of allegations following that reduced from over 460 to less than 10, and that was an important period for Operation Northmoor. And I think it links back to my earlier point on the discretion of a chief constable, because it provided a judicial basis to the decision to discontinue a significant number of investigations, because in those cases there were not circumstances that would lead a reasonable person to believe an offence had been committed.
Is that because the view was taken by Operation Northmoor and those charged with the investigation that absent a statement from a complainant to support the allegation, there was no evidence to support it and therefore no investigation was required?
That's correct. I think it probably should add to that. That didn't mean that had one been forthcoming at a later point, it could have been revisited.
So the number of allegations being investigated was reduced, as you said, from 460 to 10.
Yes.
And did that lead to a consequential reduction in the workforce as well?
It did, and it saw not only a reduction in the workforce, but it saw a restructuring of how Operation Northmoor had set itself up following that decision, so that by mid-2017, rather than having 3 teams, as I earlier described, one dealing with the most serious investigations, one dealing with the allegations of detention or detainee abuse, and one providing the supporting structures, it restructured itself to an investigations team and an investigation support team.
In terms of the 10 remaining allegations, was the key investigation that regarding Objective Tyburn and concerning the Saifullah and Bang families?
It was and remains so, yes.
In addition to that particular allegation and the investigation into what took place in the events of the 16th of February, were there 2 other principal allegations of extrajudicial killing that failed to be considered by the investigators in Operation Northmoor?
There were, and I think we will refer to them here as Objective 1 and Objective 2.
Objective 1 dating to the 7th of February of 2011 and Objective 2 to the 9th of February of 2011. Is that correct?
That is correct, yes.
In addition to those 3 allegations of extrajudicial killing, was there a further separate allegation that was investigated after information had been made available by an Afghan partner unit officer?
There was. There was an investigation which its unique reference number was 002008/2019, and it related to an allegation made by an Afghan partner unit officer that on a partnered unit, an elderly local national male had been killed by a UK SF soldier on the 20th of June 2011.
in addition to the allegation that that Afghan partner unit officer made about the unlawful killing of an Afghan national by a member of UKSF, did he also make the allegation, that's the Afghan officer, that members of the UKSF partner force would carry weapons with them to leave at the scene in case of a shooting?
He did make that allegation, yes.
In other words, what has been colloquially referred to as throwdowns.
Yes, or drop weapons, yes.
Those allegations having been made by him whilst he was being interviewed, in fact in connection with other extrajudicial killing allegations, was he then asked to return to make a formal complaint and statement about the allegations he'd said in his interview?
He was asked to return. Unfortunately, he did not and has never returned.
Have efforts been nonetheless made to try to find him?
There were efforts made to try and track him down, yes.
But as you've said, without success.
Yes.
Can I take you please to paragraph 214 and to take you to July of 2019. In July of 2019, did Brigadier Dave Neal, the then Provost Marshal Army, decide that there had been a thorough and independent investigation in which all reasonable and proportionate lines of inquiry had been pursued, but in respect of which the evidential sufficiency test had not been met for any of the unlawful killing allegations?
To the best of my knowledge, that's correct, yes.
So the result being that the investigation into Objective Tyburn, in which 4 people had died and 2 weapons were recovered, the investigation into Objective 1, in which 9 people had died and 3 weapons had been recovered, and the investigation into Objective 2, in which 8 people had died and 4 weapons had been recovered, the conclusion reached was that the evidential sufficiency test was not met, and the matter was to be referred pursuant to the relevant procedures to the Director Service Prosecutions and to the Service Prosecuting Authority.
It's correct that they determined the EST was not met, and then they consulted with, and following consultation with the Director of Service Prosecutions, it was discontinued, yes.
And in light of the support that was given to the conclusions reached by the investigating team, did the Provost Marshal Army therefore formally declare the investigation closed on the 15th of July of 2019?
He did, yes.
Can I ask you this, please? For how long had it been anticipated that Operation Northmoor would be closed down? Is this something that had been the work of a few weeks or a few months?
I don't think I can answer that with any clarity. There may be other future witnesses that are able to provide you with a more accurate view of that.
Could I just ask you, please, to look to the screen, and if we could bring up, if you wouldn't mind, exhibit page 2512. (2512) is part of the final narrative from Operation Northmoor, and if we were to just please in that particular document if we look to the middle paragraph beginning pending. Pending any decision to conclude in 2019, in late 2018, planning commenced to draw down the investigation in good order and at the same time future-proof the MOD against any legal challenge. The plan will now take many months to implement to ensure that the RMP personnel involved in the investigation are redeployed at the right time and that all records are collated and retained in the most appropriate way. Now, if that's a correct record of decisions and discussions that had taken place, it would appear that in late 2018, at least 6 months before the formal decision was taken, consideration was being given as to how to shut down the operation and how to future-proof the MOD against any legal challenge that might arise as a result of the operation ending.
Yes, and in terms of the planning to commence any drawdown, that from a military planning perspective, it would seem prudent that plans were in place before the end of a significant investigation that had moved lots of people and resources around the country, so that didn't have to be done as soon as the investigation closed. But in terms of future-proofing the MOD, I'm not sure I can offer much on that, I'm afraid.
Well, that may be for others to answer in due course. Insofar as the closure of Operation Northmoor is concerned, Brigadier Dave Neal concluded, as you just told us, that all reasonable and proportionate lines of inquiry had been pursued. Had all lines of inquiry been concluded at the time he determined that it was appropriate to shut Operation Northmoor down?
So I'm certainly aware of one line of inquiry that was outstanding beyond the closure of Operation Northmoor, because it was still outstanding until Operation Pitting happened, which was still trying to seek the statement from the Afghan partnered unit officer. So there was at least one outstanding line of inquiry.
We touched upon it briefly, but at the conclusion of the investigation was a short report for each of Objective Tyburn and Objective 1 and 2 passed to the Systemic Issues Working Group.
It was, yes.
And in reaching the decisions that were reached in respect of Objective Tyburn and Objectives 1 and 2, all three of which you told us, it was determined the evidential sufficiency test was not met, and following statutory consultation with the DSP, he agreed with that conclusion. What about any of the other operations that have been part of the TTP review that have been launched by UKSF?
So a decision was made within Operation Northmoor to expand beyond looking at purely Objective Tyburn. That, as the inquiry's already heard, left another or a number or 10 other operations that formed part of the TTP review. Objective 1 and Objective 2 were chosen to be looked at, and the advice at the time that was given to Operation Northmoor by the IAG was to look at those other two and determine whether there were any likely lines of inquiry that could be pursued successfully, and if so, to then broaden into the other operations, and if not, to reconsider where they went from that point. So hence Objective 1 and 2 came into scope, but given that they were concluded with a decision that the evidential sufficiency test was not met, a decision was taken not to look at the other TTP review.
Do you think there might have been lost investigative options as a result of that decision?
I think any delay to investigate in almost any circumstance creates challenges in then going back and recovering that evidence.
Can I briefly take you to paragraph 243 and the impact that you have identified on Operation Northmoor? You set out in your statement that it had considerable effect on the personnel involved and on the wider military police capability. You've described how it saw, in effect, the resubordination of almost a third of the SIB regiment personnel reallocated away from routine tasks, and which created gaps across the RMP and the brigade structure.
Yes, that's correct.
So presumably you and the RMP are cognizant, therefore, of the impact that this particular operation had on the wider RMP, but also on the individual investigators.
So it put pressure on the wider RMP. Almost every subunit within the RMP lost workforce structure. So in essence, lost a number of positions within it to allow for the increase up to 123 personnel within Operation Northmoor. So it affected not just the SIB, but the whole of the RMP on an organisational level. It put pressure on it. And then from an individual perspective, we did see challenges and continue to see challenges with some of our personnel, which have manifested in both mental and physical health issues, affecting them to this day in some cases.
And of course, you are providing evidence on behalf of the RMP and have therefore focused on the impact to the RMP and its personnel. But doubtless you have well in mind the observation by Mr. Justice Henriquez that in the historic investigations that have been undertaken by the RMP, there has all too often been overemphasis on the impact to the service rather than the need to secure justice for the victims.
Yes.
Can I ask for your help, please, with Operation Sestro, and can I invite you to look to paragraph 245 onwards in your statement? When we touched upon Operation Sestro at the start of your evidence, you'd identified two important factors. First, that although we're dealing with it after Operation Northmoor, it comes first in time. But second, and unlike any of the allegations considered by Operation Northmoor, this was one that had been brought to the attention of the RMP at the relevant time.
It has. I think it's important to clarify the aspect on time because the investigation came first, i.e. Operation Sestro commenced before Operation Northmoor, but the incident on in 2012 actually happened after the key incidents within that were covered in Operation Northmoor. Yes.
Just as with Operation Northmoor, can I have this clarification from you, please? At any stage were you involved in the planning, resourcing or execution of Operation Sestro?
No, I was not.
So, as before, have you had to consider the relevant material, including statements provided by the senior investigating officer and others involved in order to glean the details you're about to give us?
I have, yes.
You'd set out in your statement that on the 4th of December of 2012, the Guardian newspaper had written an article alleging that in October of the same year, British forces had shot and killed 4 boys in the Loibach area of Helmand province, and that the then Secretary of State for Defence had been asked to launch an urgent inquiry into the allegations. And you'd also identified that on the 7th of December of 2012, the Force Provost Marshal in Afghanistan had launched an investigation into the allegations of unlawful killing and ill treatment of civilians.
That's correct. And in between those two dates, it's worthy of note that following the news article, which the SIB regiment within the UK saw, the SIB regiment in Bulford alerted 62 section SIB of this to see whether or not they were aware of the allegations, which actually allowed them to recover some evidence quite quickly. And another key event between them is that on the 6th of December 2012, a pre-action protocol letter was received from a UK legal firm, which was sent to the commanding officer of the SIB regiment.
As far as you're aware from what you've come to look at, was any allegation made of civilian casualties before the newspaper article in The Guardian in December?
I'm aware that there were... So no information was passed to the SIB regiment, but I'm aware that there was knowledge of the incident or an incident within one of the headquarters within Afghanistan.
So one of the headquarters in Afghanistan was aware of an allegation of civilian casualties at the hands of British service personnel.
I believe so, yes.
And if that belief is correct, would you have expected ordinarily that information to have been passed to the SIB in order that they could begin an investigation into how it was that civilians had been killed by British servicemen or women?
Yes.
But in fact, you would say that the first time that SIB were made aware of the allegation was not until December after the article was published in The Guardian.
Yes, and I say that because I'm aware that the SIB regiment referred themselves to another policing agency to consider whether or not there were any failings on behalf of the RMP to react quickly enough.
And having referred themselves, what was the conclusion of the other service police force?
The conclusion was, in fact, the conclusion and the report was that there was no culpability from the RMP for failing to investigate sooner.
Can we just look at some of the investigative steps that were taken by the senior investigating officer and then look to how it was that that particular allegation came to be concluded? Can I take you first in your statement to paragraph 248? And have you identified from the SIO's statement that he had set multiple actions which included but were not limited to identifying the UK Special Forces personnel who had been on the operation, to recovering operational paperwork, to establishing whether there was any video footage of the operation, tracing and interviewing witnesses? He had requested copies of information held by the law firm who had begun the action, and he'd even considered visiting the scene and conducting, as he termed it, house-to-house inquiries if it was safe to do so.
That's correct, and I think that shows that where, even though she knew that many of those would not be possible, she at least considered them and explained the rationale of why they weren't possible.
So, in effect, the SIO had considered those steps that might normally be taken in what the murder manual terms the golden hour.
Yes.
And had tried to see whether it was possible, notwithstanding the passage of time, to implement those steps. But, for example, the visit that she had hoped to conduct to the scene in order to speak to people there, she'd identified that that particular area of Afghanistan had been transitioned back to Afghan security control, and that it would require a joint UK and Afghan operation in order for SIB to travel there.
That's correct, yes.
So it would necessitate taking soldiers and equipment away from other operations in order to take her and any of her investigators out to the scene.
Yes.
In addition to identifying the various lines of inquiry that she wished to pursue, did the SIO start to take statements from the UK SF personnel who'd been on the operation?
Yes, she did, very quickly.
Notwithstanding the speed with which she had begun that, was it a difficult exercise to complete because the members of that particular group were on their way back from deployment and returning to England?
That's correct, and actually that meant that some witness statements were actually taken from individuals in the airport departure lounge.
insofar as any progress was made on the attempt to recover video footage that might exist, did the SIO discover, when she tried to get hold of relevant surveillance footage, that the footage had been overwritten and that there was a hard drive error which frustrated attempts to recover it?
That's correct, yes.
Was further information received that, in fact, there had been 3 people in the room at the time of the shooting, one a member of UKSF who was termed Soldier B, and 2 members of the Afghan partner unit?
Yes.
And were the investigators informed that neither of the Afghan partner unit personnel was willing to cooperate with the investigation?
They were informed of that, yes.
Was advice then received from the legal advisor to UK Special Forces that there was a discrepancy within the paperwork that had been supplied by SF to 62 Section SIB, and that who had fired first was not as clear as it might have once been on the paperwork first provided?
That's correct. Initial indications indicated that those Afghans in the room had fired first. However, an alternative account suggested that the coalition forces had acted preemptively due to the imminent threat to their lives. And when the legal advisor spoke with 62 Section about that, they noted that the latter, i.e. the preemptive firing, was in fact the correct version of events.
And in due course, was the difference between those accounts explored in interview with Soldier B?
It was, yes.
Insofar as it was possible to get information from the Norzai family who were affected by the events that Operation Sestro was investigating, was it difficult to contact them during using any conventional methods?
Yeah, there were real challenges with utilising normal trace and contact methods that would be familiar to a Home Office police investigation, such as phone contact, or by even turning up and knocking on someone's door. So the SIB attempted to utilise the Afghan police to try and establish communications. This was unsuccessful and led to challenges from the representatives of the families. And it's perhaps useful to highlight, further indicative challenge of operations and investigating on operations, that even contacting those that you may wish to speak to in a foreign country, in a different language, with a different culture, is extremely difficult at times.
Was in fact a point reached at which consideration was even given to concluding the investigation, because there was at that stage apparently insufficient evidence to proceed any further?
That's correct, and I'm aware of that from both the statement of and a conversation with the senior investigating officer, who did start to feel around that time, which I think was about March 2013, that she may have to conclude the investigation, as there appeared to be further evidence to proceed any further. However, that changed when, towards the end of March 2013, she received hard copies of 3 signed witness statements from Afghan nationals, at which point she decided to recategorise the investigation from being a special investigation, as we spoke about earlier, to classify it as a murder investigation. That didn't change the manner in which the investigation was conducted, and her rationale for that, as she highlights in her statement, was to ensure that it was correctly focused.
Was there then a protracted period of just less than a year, during which there was engagement between the investigators, the UK authorities and lawyers acting for individuals to try to secure evidence from the Afghan civilians?
There was, and it proved challenging. They attempted to, they looked at multiple options of doing this, ranging from meeting with those Afghan civilians on ISAF bases or in third-party locations, both of which proved unfruitful due to security concerns. And likewise, consideration was given to meeting them in a neutral location within Afghanistan, but again, security concerns for the UK forces involved precluded that.
Were interviews nevertheless conducted with Soldier B, who it was believed had fired the fatal shots, and with Soldier A, who was the officer commanding the call sign at the time?
Yes, that's correct.
And following various interviews with the two of them, was Soldier B informed in February of 2014 that he was going to be referred to the Director of Service Prosecution in respect of allegations of murder?
Yes, he was.
And was Soldier A initially referred to his commanding officer and then subsequently referred to the Director of Service Prosecutions in May 2014 in respect of allegations of misconduct in a public office?
That's correct.
There was a third soldier, Soldier C, who also was the subject of an investigation. And did the involvement of Soldier C arise after efforts had been put in place to travel to Afghanistan and to interview members of the Afghan partner unit who had been involved in the operation?
Yes, that's correct. And ultimately, the plans to conduct the interviews required force protection, which came from another UKSF unit in theatre. And it was the belief of the SIO that Soldier C had deliberately obstructed her from carrying out an interview with a key witness, which prevented the investigation obtaining vital evidence. And therefore, Soldier C was referred to his commanding officer and subsequently again to the Director of Service Prosecutions for obstructing the course of public justice.
So it was the conclusion of the RMP that in respect of Soldier B, Soldier A and Soldier C that the evidential sufficiency test was met and that they were referred to the Director of Service Prosecutions in respect of the allegations, as I've already set out, of murder for Soldier B, for misconduct in public office for Soldier A, and obstructing the course of public justice for Soldier C.
That's correct.
On the 5th of March of 2015, was Operation Sester informed by the Service Prosecuting Authority that the conclusion had been reached by the lawyers within that organisation that there was insufficient evidence to prosecute and non-direction notices were issued in respect of soldiers A, B and C?
Yes, that's correct.
You've identified towards the end of your statement a number of additional investigations in respect of murder and manslaughter and sudden death and special investigations, and you've provided a lot of information in regard to those various allegations. Insofar as they are concerned, is the position this, that either material has already been provided to the inquiry or material is in the process of being provided to the inquiry so that the inquiry can look out into those individual matters?
Yes, that's correct.
I'm not going to take you through any of those in particular, but simply to record that as you and the RMP in particular have been asked for assistance, you've been able to provide it as quickly as possible.
Yes.
Can I just deal with a handful of other matters, please, if I may? Two things to correct, which I think are my fault and not yours. So can I begin by an apology, Colonel Rotchell? When I asked you about the capability within the RMP for officers to have placements with Home Office police forces, I'd asked you about the period which we're currently involved, as in timely right now, and we know from what you told us that it certainly, as at today and in the last few years, it's been the approach of the RMP to ensure that its GPD as well as its SIB members have the opportunity to work with Home Office police forces in order to better assess investigations that are taking place there, which are greater in number and possibly sometimes more serious. So it's a learning experience that you have made available to your personnel. What I neglected to do was to ask you whether the position was the same in 2010 and 2013. And if it wasn't, I want to ask you about that, because I don't want anyone to be given the impression by my question that you were answering about the relevant period for this inquiry rather than as at today's date.
So to the best of my knowledge, there were external placements going on in that period, but what they weren't was as codified and as clear in terms of a programme as they are today. I think that it would perhaps be helpful if you are amenable to this, so if I go away and find out a clear answer for that and submit it to you.
Yes, please.
Yeah.
That would certainly be of assistance to us. The other matter in which I think I led you into error, and again I apologise for so doing, I was asking you questions about the 24-hour moratorium or gap that there might be when speaking or being permitted to speak to members of the Special Forces in connection with any allegation. And you had very helpfully taken us to the various policies, and you'd identified one as recent as 2016, which is exhibited by you as KR 61 in your statement. I don't need to take you to the physical exhibit itself, but just to clarify, as at 2016, was the 24-hour moratorium still in place in that guidance or policy note that was shared between you and the UKSF?
No, so in the three extant protocols, it existed in 2008, it existed in 2013, but it was removed in the 2016 protocol.
Can I just check with you what the page number is for that, in case I'm looking at the wrong document? It's KR 61, is it?
So KR 61 is the 2016 version of the policy. The 2008 and the 2013 protocols were not disclosed as exhibits because they were referred to with their MOD disclosure numbers in the request for the corporate statement as documents that had already been disclosed to the inquiry.
If you have KR 61 available to you, could I just invite you to look, please, in case I have misunderstood something? There is section 10, which is headed cooperation.
Oh, sorry. Yes, I can see it.
If we look to the bottom of that, it goes over the page.
Yes, it does, and you are correct. It hasn't been removed from the 2016 version.
So it looks like we've both got each other confused. In the
Thank you.
afternoon.
And it was considered for removal in a 2010 document, but clearly hasn't. My apologies.
And I think what you did note in your statement was that that policy is currently under review.
That's correct, yes.
And there is not presently a finalised version of it, but it is your understanding that the question of a 24-hour moratorium is up for grabs in the new policy, if I can put it that way.
I mean, I can speak on behalf of Provost Marshal Serious Crime.
Yes, please,
on this matter. His view is that that is a non-negotiable in terms of its removal. And I speak on behalf of Provost Marshal Serious Crime because Provost Marshal Serious Crime now is ultimately responsible for the oversight of serious and complex investigations, whereas pre the 5th of December 2022, it was Provost Marshal Army.
Can I just deal with a handful of general matters that I hope will assess in rounding off your evidence? Everyone will be cognizant of what you've told us about the difficulty in conducting criminal investigations in an armed conflict and in theatre. And everyone will be now aware of the potential that there might be for conflict between RMP personnel and SIB officers who have been living and fighting alongside people they might be asked to investigate. And also, we have dealt helpfully with you with the obligation and the expectation on people, be they conventional forces or special forces, to assist all RMP investigations. But of course, there's no obligation that sits with them to give a statement. Insofar as it's possible for you to help us, when it comes to investigating individuals who work sometimes in small units and closely together, and who have forged a bond between them on which each other's lives can depend, do the RMP struggle to break through that bond and to conduct as detailed an investigation as they would like?
I'm not sure I understand which perspective are you seeking the perspective of those RMP soldiers who have been integrated into those units and breaking that bond between them and the unit that they've been serving with?
Perhaps both. The difficulty faced with breaking the bond to the unit they've been served in, but also breaking the bond of the unit itself in order to effect a proper investigation within that unit.
So I think if I answer first from the perspective of RMP personnel deployed with units, and as we've said multiple times today, you know, living and fighting alongside the people that they potentially have to investigate. I think that comes back to our professional obligation and our requirement to uphold the correct values and the correct standards, both of the Army and those that we expect of our military police officers. I think likewise, the same broad principles apply to those individuals within units. And I can only offer again a referral back to the views of that Brigadier Ebel described yesterday about the importance of courage, the importance of integrity, and of doing the right thing. Is there potential for challenge or for challenges in that space? I think yes, but that's why the values and the standards of the Army are essential, and that's why the training and the inculcating of those values and standards is absolutely pivotal to ensure that.
And this is not meant as a criticism of you or the RMP, but in one of the conclusions reached by Her Majesty's Inspectorate of Constabularies and Fire and Rescue Services, was it noted that despite the Queen's, now King's, regulations, that the RMP occasionally faced reluctance on the part of potential witnesses to help. And indeed, there were even instances of witness intimidation. In other words, occasions where potential witnesses were persuaded, threatened, or frightened into not giving an account.
Yes, they did. They did know that.
And that may not be peculiar to the Army. That may be common all over. But undoubtedly, is it a fair observation that when one is dealing with a close-knit group of individuals who live and fight alongside each other, that sometimes their loyalty to each other can be greater than their loyalty to the British Army and the values and standards that it seeks to embody?
I think that's a fair observation.
One of the observations that Her Majesty's Inspectorate of Constabularies and Fire and Rescue Services had made was that it was incumbent on the Army's leadership to send and reinforce a robust message about what constitutes unacceptable behaviour. And presumably, when you seek to, by our example, we shall lead, when you seek to embody that, you are hoping that you are an example to the rest of the British Army as to how they should and are expected to conduct themselves.
Yes.
Colonel Rotchell, thank you very much for your help, sir. One moment. I do apologise. Can I just check something? That's all that I wanted to ask you, Colonel Rotchell, but what I wanted to do was this, because you have politely answered my questions now for several hours. And what I'd like to do is to give you an opportunity to add anything that I have not been able to ask you, because Admiral Radakin was given the same opportunity, and it's only right that you, as a representative of the Royal Military Police who have come to assist us in such a fashion, are given an opportunity to say anything that you think will assist us, the inquiry, or indeed help shine a light on the duty of others to assist us as we move forwards.
Thank you. And sir, if I may first reaffirm our commitment to support the inquiry. Both Provost Marshal Army and Provost Marshal Serious Crime fully endorse the need for it, and we will continue to approach it with the respect, the gravity, and the transparency that it rightly demands. We thank you and the inquiry for the opportunity to provide some context, specifically to the realities of policing in operational environments, and to investigating the allegations that arise from them. Conflict rarely stops because allegations of wrongdoing are made, and the time, the space, and the resource one would wish for rarely, if ever, exist. And the Royal Military Police can only investigate what it's made aware of within the resources provided to it. And our people do so without fear or favour. This is not an easy task, and we firmly believe that the Royal Military Police and the wider service police community remain uniquely placed to confront and to address these challenges. But if there are lessons that need to be learnt, we stand by to do so. And in many areas, we're already implementing positive and progressive change. We do so to continuously drive forward the effectiveness of the service police as a key component of the service justice system, which is essential to ensure the operational effectiveness of His Majesty's Armed Forces. Doing so both safeguards the reputation of defence and, importantly, secures the public confidence of those we're entrusted to represent. And if I may finish, sir, by returning to the first line of Mr. Greene, King's Counsel's opening statement to the inquiry, and specifically to reinforce the firm belief of the Royal Military Police that soldiers on military operations are not outside or above the law. Thank you.
Colonel Rotchell, thank you for that. Thank you for coming to give your evidence today. We've covered a great deal of useful ground today, and I'd like to thank, as I have in the other days, you and your team for all the work that has gone into this. I'd like to thank also Mr. Glasgow and the Council to the Inquiry team for all the work that this week is involved. We're going to adjourn now. An announcement will be made shortly as to the next tranche of open hearings. I'd like to thank everybody for their attendance and the care with which they have listened to this important opening evidence. Can I also thank the court staff and those behind the scenes who've made sure that the live streaming has gone extremely smoothly, so as many people as possible can observe this public inquiry in operation. Thank you very much indeed.